In this series of lectures, we would like to discuss about law of arbitration. So, first we'll discuss the very introduction of arbitration. So, the very process of arbitration helps in coming to an arrangement for taking and abiding by the judgment of a third person in some disputed matter between parties instead of carrying it to the established courts of justice. The third person is called arbitrator. The fundamental rule of arbitration is that both parties to a dispute have to agree to an arbitration beforehand. This is called the arbitration clause, which needs to be incorporated into a contract so that any future dispute can be settled through arbitration and not a court of law. If not for this clause, the whole idea cannot be called arbitration. The arbitration clause is to ensure that only consenting parties reach the arbitration tribunal, like the rest of those laws where a person can be pulled off in a court of law. The parties to the dispute can get their dispute resolved with speed, convenience, and simplicity of procedure, secrecy, and without much expense. The civil courts have a backlog of cases. There are more formalities to be observed. This is not so in the case of arbitration, and in consequence to that, the Indian Parliament enacted the Arbitration and Conciliation Act of 1996, and the act has been keeping in the mind the following: as per the adoption of the International Commercial Arbitration by United Nations Commission on International Trade Law in 1985, and also the recommendations of the General Assembly by the United Nations that all countries give due consideration to the said model law in view of the desirability of uniformity of the law of arbitral procedures and the specific needs of international commercial arbitration practice, and also the very adoption of United Nations Commission on International Trade Laws. the conciliation rules by the United Nations and the recommendation of the General Assembly of United Nations to use the said rules in cases where a dispute arises in the context of international commercial relations and the parties seek an amicable settlement of the dispute why recourse to conciliation. The said model law and rules make significant contribution to the establishment of a unified legal framework for the fair and efficient settlement of disputes arising in international commercial relations. Also, it is expedient to make law respecting arbitration and conciliation, taking into account the aforesaid model law and rules enacted by the United Nations Commission on International Trade Law in 1985. So, in consequence to that, India enacted the Arbitration and Conciliation Act in 1996 with the very objectives that to consolidate and amend the law relating to domestic arbitration, international commercial arbitration, enforcement of foreign arbitral awards, and also to define the law relating to conciliation and for matters connected therewith or incidental thereto. So, in that connection, we would like to discuss which matters could be referred for arbitration and such matters which could be referred for arbitration as such provided under any matter in dispute between parties relating to private rights or obligations which civil courts may take cognizance as provided under Section 9 of the Civil Procedure Code 1908 may be referred to arbitrations unless a reference is forbidden by a statute or is opposed to public policy. So, we would like to discuss which such matters which could be referred to arbitration and such as regarding determination of damage in case of breach of contract, also time-based claims, also matters of personal or private rights of the parties, as for example, right to hold an office. And there are also certain matters which could not be referred to arbitrations, and such matters which cannot be referred to arbitration are insolvency matters, matters of criminal nature or based on illegal transactions, also testamentary matters like the validity of a will, and also matrimonial matters as relating to divorce or restitution of conjugal rights, and also matters relating to public charities and charitable trust, and also matters relating to guardianship of a minor, and all lunacy proceedings in a court of law. So all these matters cannot be referred for arbitration. So now we'll discuss the very judicial intervention as provided under the Act. An arbitrator does not have any powers to grant injunction. However, at times it becomes necessary to seek judicial intervention. So, Section 9 of the Act provides for such an intervention at the request of an aggrieved party under certain situation. A party to an arbitration agreement may before or during arbitral proceedings or at any time after the seeking of the arbitral award, but before it is enforced in accordance with the provisions of Section 36, apply to a court for appointment of a guardian for a minor or a person of unsound mind for the purpose of arbitral proceedings or for an interim measure of protection in respect of any of the matters following under in regards to the preservation, interim custody, or sale of any goods which are the subject matter of the arbitration agreement, also securing the amount in dispute in the arbitration, also the detention, preservation, or inspection of any property or thing which is the subject matter of the dispute in arbitration, or as to which any question may arise therein, and authorizing for any of the aforesaid purposes any person to enter upon any land or building in the possession of any party, or authorizing any samples to be taken or any observation to be made or experiment to be tried which may be necessary or expedient for the purpose of obtaining full information or evidence, and so also interim injunction or the appointment of a receiver, and also such other interim measures for protection as may appear to the court to be just and convenient. So, this is all relating to judicial intervention. And now we'll go to what exactly arbitration agreement means, as according to Section 67 of the according to Section 7 of an arbitration agreement means an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. A non-contractual legal relationship may arise from a tort. The arbitration agreement may be in the form of an arbitration clause in a contract, or it may be in the form of a separate agreement. In any case, it must have all the essential elements of a valid contract as stipulated under the Indian Contract Act 1872. So, in regards to arbitration agreement as provided under Section 7, there are different types of arbitration agreements. Primarily, we found there are three types of arbitrational agreement. So, the first one, agreements between individual parties wherein the agreement itself contains an arbitration clause. And the second type of arbitration agreement is that agreement with the government or a public body which contains an arbitration clause, that being the standard form of agreement adopted by government departments. And in the third type of arbitration agreement is institutional arbitration agreements, under which the members of an association are bound by the arbitration machinery created by and functioning under the rules of the association. If there is a dispute between the two businessmen who happens to be members of the same trade association, then they will refer the dispute to arbitration, as it is required to be done under the rules of that association. And now we'll discuss exactly the very composition of arbitration tribunal. So, Section 10 of the Act provides the following ways of the composition of arbitral tribunal. The parties are free to determine the number of arbitrators. However, this number cannot be an even number, but the arbitration agreement may provide for even a sole arbitrator to be nominated by any of the parties to the contract. And on default of any such determination as given in the first clause above. The arbitral tribunal shall consist of sole arbitrator, and the Act does not prescribe any qualification, whether academic or professional, for a person to act as an arbitrator. And now we'll discuss regarding the very appointment of arbitrators. The procedure for appointment of arbitrators can be set out by the parties in their agreement. In absence of any such agreement, the appointment should be made upon the request by a party to the contract by the Chief Justice of the High Court or any person or institution designated by him. In an international commercial arbitration, the reference to Chief Justice would be means the Chief Justice of India. So, this is all regarding the very composition and appointment of the arbitral tribunal. And now we'll discuss the very jurisdiction of the tribunal. So, exactly section 16 of the Arbitration and Conciliation Act of 1996 provides that the arbitral tribunal is empowered to rule on its own jurisdiction, including ruling on any objections with respect to the existence or validity of the arbitration agreement. For this purpose, it is further provided that an arbitration clause which forms part of a contract shall be treated as an agreement independent of the other terms of the contract, and a decision by the arbitral tribunal that the contract is null and void shall not entail the invalidity of the arbitration clause. A plea that the arbitral tribunal does not have jurisdiction shall have to be raised before the submission of the statement of defense before the arbitrator. However, a party will not be precluded from raising such a plea merely because he has appointed or participated in the appointment of an arbitrator. Similarly, a plea that the arbitral tribunal is exceeding the scope of its authority has to be raised as soon as the matter alleged to be beyond the scope of its authority is raised during the arbitral proceedings. So also the arbitral tribunal may in either of the case mentioned in the above two clauses that already we have dealt, admit delayed plea if it considers the delay justified. Further, the arbitral tribunal has to decide on a plea about the lack of jurisdiction or about the tribunal exceeding the scope of its authority, or if the arbitral tribunal takes a decision reflecting the plea, then it shall continue with the arbitral proceedings and make an arbitral award. A party aggrieved by such an arbitral award may make an application under Section 63 of the Act. And now we'll discuss the very conduct of the proceedings before the arbitral tribunal. So, as it is provided under Section 18 to Section 27 of the Act, equal treatment of parties, as provided under Section 18, that the parties shall be treated with equality and each party shall be given full opportunity to present his case. And as also Section 19 provides that the arbitral tribunal is neither bound by the Code of Civil Procedure 1908 nor by the Indian Evidence Act 1872. The parties are free to agree as regards to procedure to be followed by the arbitral tribunal. However, if they fail to decide in this regard, the arbitral tribunal is empowered to follow such procedure as it considers appropriate. The power of the arbitral tribunal mentioned above includes power to determine the admissibility, relevance, materiality, and weight of any evidence. And as Section 20 provides regarding the very place of arbitration, the parties have freedom to agree on the place of arbitration. Failing any such agreement, the place of arbitration has to be determined by the arbitral tribunal having regard to the circumstances of the case, including the convenience of the parties. Notwithstanding the above, the arbitral tribunal may, unless otherwise agreed by the parties, meet at any place it consider appropriate for hearing witness, experts, or the parties, or the inspection of documents, goods, or other property. And Section 21 provides about the commencement of arbitral proceedings. And Section 22 exactly provides the provisions about the language to be used in the arbitral proceedings. And as such, the very statements of claim and defense, the pleadings in arbitral proceedings is provided under Section 23, and Section 24 provides the very hearings and written proceedings. And in case of default of a party as provided under Section 25, the very consequence of the default would be the claimant fails to communicate his statement of claim in accordance with Section 23, or the respondent fails to communicate his statement of defense in accordance to Section 23, a party fails to appear at an oral hearing or to produce documentary evidence. All these are falling under Section 25 in regards to default of a party. And now we'll discuss exactly about arbitral award, and which is provided under Section 28 to Section 33. So, In regard to that, Section 28 simply provides rules applicable to substance of dispute. And as Section 29 provides the decision making by a panel of arbitration, and Section 30 provide the very scope of settlement between the parties. And as regarding the very arbitral agreement and the very award, under Section 31 of the Act, which provides an arbitral award shall be made in writing and shall be signed by the members of the arbitral tribunal. However, in arbitral proceedings with more than one arbitrator, the signature of the majority of all the members of the arbitral tribunal shall be sufficient so long as the reasons for any omitted signature are stated. So also the arbitral award shall state the reason upon which it is based. However, in the following cases, it is not necessary to give the reason by the tribunal while awarding any arbitral award. In that regard, the parties, if they have agreed that no reason had to be given, in that case, the arbitral award would not mention the reasons, and the award is an arbitral award on agreed terms as provided under Section 30. So the 1996 Act has thus made a speaking award mandatory except in two cases. A speaking award is one which states the reason for the decision of the arbitrator, and a non-speaking award does not do so. The arbitral award shall state its date and the place of arbitration as determined and as provided under Section 20 of the Act, and the award shall be deemed to have been made at the same place. After the arbitral award is made, a signed copy shall be delivered to each party. The arbitral tribunal may at any time during the arbitral proceedings make an interim arbitral award on any matter with respect to which it may make a final arbitral award, unless otherwise agreed to by the parties, wherein insofar as an arbitral award is for the payment of money, the arbitral tribunal may include in the sum for which award is made interest at such rate as it deems reasonable on the whole or any part of the money, for the whole or any part of the period between the date on which the cause of action arose and the date on which the award is made. Further, a sum directed to be paid by an arbitrator award shall, unless the award otherwise directs, carry an interest 18% per annum from the date of the award to the date of payment. Unless otherwise agreed to by the parties, the cost of arbitration shall be fixed by the arbitral tribunal. Further, unless otherwise agreed by the parties, the arbitral tribunal shall specify the following in the arbitral award. The party entitled to cost, the party who shall pay the costs, the amount of cost or method of determining that amount, and the manner in which the cost shall be paid. So the very word cost as used means reasonable cost relating to the fees and expenses of the arbitrators and witnesses, the legal fees and expenses, any administrative fees of the institution supervising the arbitration, and any other expenses incurred in connection with the arbitral proceedings and the arbitral award. So, the very arbitration proceedings in an arbitral tribunal, when finally the proceedings concluded, when the arbitral award is issued, and in that case, the very cost would be decided by the arbitral tribunal itself. And now we'll discuss some other important aspects relating to the act, and that is relating to the power of the arbitrators. And as such, the very powers of the arbitrators, the very purpose is conducting arbitral proceedings. The arbitrators is to arrange for administrative assistance by a suitable institution or person in order to facilitate the conduct of the arbitral proceedings as provided under Section 6 of the Act. So also to rule on its own jurisdiction, including ruling on any objections with respect to the existence of validity of the arbitration agreement as provided under Section 16 of the Act. And as Section 17 of the Act provides to order a party to take any reasonable measures in respect of subject matter of the dispute. And while Section 19 of the Act provides the powers of the arbitrators to conduct the arbitral proceedings in the manner in which it considers appropriate. And as such, under Section 20, the power is to determine the place of arbitration having regard to the circumstances of the case, including the convenience of the parties. And Section 29 provides that to determine the very language to be used in the arbitral proceedings. And Section 23 of the Act provides that to determine the time frame for filing statements of claims by the claimant and the defense by the respondent. And Section 24 provides that the arbitrators to decide whether to hold oral hearing for the presentation of evidence or for oral argument, or whether the proceedings shall be conducted on the basis of documents and other materials. And some other powers of the arbitrators as such to decide on default of a party to communicate his statement of claim, to communicate his statement of defense, or to appear at any oral hearing or produce documentary evidence and in such case of default as provided under section 25, it is only depend on the power of the arbitrators to take decision. And as section 26 provides that to appoint one or more experts to report on specific issues to be determined by the tribunal. And also, Section 27 provides that the arbitrators to take court's assistance in taking evidence and also to fix cost of an arbitration as provided under Section 31, and also it would have a lien on the award for any unpaid cost of the arbitration as provided under Section 39 of the Act. Also, the arbitrators has the power to make alteration in the award to correct computation errors, the clerical or typographical errors, or any error arising from any accidental slip or omission. Any error which is apparent on the face of the award. So now we'll discuss the very duties of the arbitrators and the very duties of the arbitrators. The Act imposes a number of duties on the arbitrators, and as such, the very first duty to see that his appointment is in order after he receives the notice thereof. And the second duty to satisfy himself that the disputes which are dealt with are within the scope of the arbitration. And the third one to enter into the reference with all reasonable dispatch and make an award within the prescribed time. And further to act judicially and impartially by giving a fair hearing to the parties, not communicating secretly with any party, giving an opportunity to parties to substantiate their respective claims, and the duty of the arbitrator to stand indifferent between the parties and not to have any interest, direct or remote, in the subject matter of the dispute or in the parties. So also, the duty of an arbitrator to disclose in writing any circumstance likely to give rise to justifiable doubts as to his independence or impartiality. The arbitrator's further duty is to encourage settlement of the dispute by mediation or conciliation or other proceedings. So another duty imposed on the arbitrators to avoid misconduct on his part or in the proceedings in any way, as for example, by accepting improper gratification or bribe from a party or by showing bias or partiality towards the party. Also, another duty imposed on the arbitrators to avoid exceeding his authority and to be within the scope of the arbitration agreement. Also, the arbitrators are duty bound to observe the rules of natural justice. And finally, it is the duty of the arbitrators to give final award on the and of the arbitration proceedings. So, in that connection, almost we have discussed the very provisions of the Arbitration and Conciliation Act of 1996, which provides one part of the provisions of the Act in regards to law of arbitration. We have discussed the very introduction, meaning, and the borrowing of certain international rules of international conventions in regards to international trade law, and also we have discussed which matters could be referred to arbitration and certain matters are there which could not be referred to for administration, and in which circumstance there would be judicial intervention as provided under section 9 of the act. And also we have discussed regarding what exactly arbitration agreement means and the composition of arbitral tribunal, their jurisdiction, and the very conduct of arbitral proceedings, and also finally the arbitral award by the arbitral tribunal, and also we have discussed the various powers laid down in the act of the arbitrators and also the very duties imposed under the act for the arbitrators. And in our next upcoming lecture, we will discuss two international conventions. One is the New York Convention Awards, and the second is Geneva Convention Awards. And finally, we would like to discuss at present about the draft arbitration and conciliation amendment bill presented in the parliament in the month of February 2024, making substantial amendment of some important provisions of the existing amended act of 1996, because it was previously amended in 2015 and 2019 and also in 2021. So that we would like to discuss in our upcoming lecture.